You found us. This is the Our Practice Makes Perfect podcast. You are welcome in this place. Now, today's topic is liens, construction and mechanics liens. So, if you are a general contractor, subcontractor, subcontractor, architect, interior designer, anything like that, this topic will have a direct effect on your life. And I know what you're thinking. If you're not one of those parties, Jeff, I'm not a roofer, painter. Damn it. What do I care about this topic? Steady. I have much to say in and around the topic of liens, and I'm not going to go too much into the weeds on what it is to actually file the claim of lien, the notice you have to give. I'm not going to get into those kinds of details. It's the stuff that I have to say around the topic that I know will interest you. So, here we go. So as you know, our firm is a business and real estate law firm. So we do stuff that business owners and real estate investors care about. That includes, of course, contracts of all kinds, really, disputes, so litigation and arbitration. Today's topic is really what falls under construction law. And I would not consider our firm to be specifically a construction law firm, though we do basically everything that they do with one exception. Exception is we don't file construction defect lawsuits. I'm not here to judge anybody, but it is sharkish. That world is sharkish, and let's talk about it because this is very pertinent to our topic today. I'm not sure the best way to say this, but you know this. If you're out in that world, you know that it's a shark tank. Let me give you some specific examples so you can understand. There are, in my opinion, some perverse incentives. Okay, now, for all of us who are professionals and all of you who are tradespeople, you likely have some kind of an insurance policy. In our case, as attorneys, we have errors and omissions insurance. You probably have something very similar. Well, everybody knows that. And everybody also knows that those insurance companies will pay out. And if you think about it from an insurance company's point of view, it makes sense, right? Because to them, it's just math. They don't really care a whole lot about who's right and who's wrong. It's just the math of it. All right. Now, if they have to lawyer up and deal with litigation that's probably going to take multiple years, how much is that going to cost? Just in legal fees alone. 20 grand minimum, 50 grand more likely, 100 grand quite possibly. So for these insurance companies, it makes much more sense to cut a check right at the beginning. Cut a check for 10 grand, 15 grand. They still come out way ahead, right? Well, project owners understand that. They understand that reality. They know that these insurance companies are almost anxious. They're expecting these lawsuits, and they're almost anxious to cut that $10,000 check, that $15,000 check. So, look, if you have 20, 30 different contractors working on a project and that many insurance policies, you almost have to bring a lawsuit, right? Like a construction defect lawsuit, because you're going to collect some easy money off of those deals. Now, let me hasten to add, I'm not saying that all these construction lawsuits are bogus or that they're just a money grab necessarily, but I got to tell you, some of the complaints that I read, because even though we don't bring these lawsuits, we do defend them. And some of these complaints are very bare bones, right? They don't get into any details about what the actual defect was. They don't get into many details at all. Really, those complaints almost just say, if you had anything to do with this project, you did something wrong. So we're naming you and give us your insurance information. So that's why I would not call our law firm a construction law firm. We don't do that kind of work. We defend it, but we don't initiate those kinds of lawsuits. But while we're on the topic of perverse incentives, let's keep going because some of this is going to start sounding very familiar to you. If you are a project owner or a general contractor or developer, you know that there's a good percentage of subcontractors who will not put up a huge fight if you don't pay them, right? Very many of them will just walk away. Maybe there's some status issues, immigration status issues, or they just don't want to take on the company with the bigger pockets, or they're just going to move on with their lives. I mean, they're just going to eat it, right? A percentage of them will just simply walk. All right. Now, there's another percentage who will put up a fight. You know, they're gonna whine about it, but they will settle for less. They'll settle for half of what their fee was supposed to be, or 3/4, or whatever, but less than the full amount. And then there's a percentage who may actually put up a fight, but because you do have bigger pockets and better lawyers probably, they will lose. So if you look at it from that point of view, if you're the project owner, if you are a general contractor, you have an incentive to just don't pay a lot of people. That's the reality. And then a final example would be the classic buy yourself some time, right? The time value of money. If you're a project owner, if you're a contractor, you would much rather pay somebody months from now than pay them right now. You know, cash is king. Hold on to your cash. Wait for your financing to come in. Wait for the sales to start. Wait for whatever. It's just going to be more cost effective to you in the long run if you could put off paying people who did the work for as long as possible. So if you're in the real estate business, you know, you're a builder or you're a rehabber or you have anything to do with that industry, this is the environment you're in. And you know that. You've already had these experiences, I'm sure. In fact, I'd love to hear about it. Drop me some comments below. So that's why everybody's always screwing everybody. Don't be surprised. Be prepared. Shoot, I forgot to announce it. That was part 1. Let's start with part 2. All right, what can you do to protect yourself in this Shark Tank? 1, obviously, have a contract. I say obviously, but you know who you are. Many of you think that this is still the world of a handshake, gentleman's agreement. No offense, ladies, just expression. But if you haven't learned yet, you soon will. That's not the way this works. And I just went through the explanation of the perverse incentives that exist so that you would understand that even though the person in front of you will look you dead in the windows of your soul, and you may think you're dealing with the most honorable person there is, my word is my bond. Those incentives are not going anywhere. And money is money and business is business. So it's not the kind of place, not the kind of environment where you can get away with a handshake. But let me give you some specific reasons why you want to have a contract. The first might seem obvious, but let me give you some examples. You don't want to have to prove the terms. Watch how easy this is. Let's say that the job was worth $5,000. Let's say you put on a roof, built a brand new roof, $5,000 job. Okay, I'm the homeowner. No, it wasn't. I agreed to pay $2,500. See how easy that was? Now it's up to you to prove that the job was $5,000 and not $2,500. Now you have to hire me. I have to spend time going through text messages and emails and looking for witnesses, and you see what I mean? Now you've just given yourself an incredible task just to establish what the most basic term of the agreement was. Oh, here's another common one. So let's say you couldn't do your work because there was some delay. You know, you had to wait for some other guys to come in and do their stuff before you could do your stuff. Very common, right? So I'm the homeowner now, or I'm the project manager. No, I don't recall any of that. I don't remember saying that there was going to be some delay and we both understood that you weren't going to be able to get the job done until X date in the future. No, you were late, you were negligent. Again, now it's up to you to prove that that conversation really happened. Not such an easy thing to do. Bottom line, have a contract. Good to have a contract also because you can then toss in the attorney's fees clause, meaning that whoever wins the litigation wins also the award of their attorney's fees and all the costs for the lawsuit. Now, that's important, obviously, from the point of view that if you do end up in litigation, you want to be able to recover all those legal expenses from the other side. But it's also good just for psychological effect, because now the builder, the owner, this entity with deeper pockets, presumably, will have to think twice, because now they know that even though they have deeper pockets than you, you're going to go scrounge up the money, you're going to fight the litigation, and when it's all over with, you're going to be able to recover from them and their deeper pockets, which makes them collectible. If you didn't see our last episode, we got into this in the landlord-tenant context. Check that out, because It's very interesting. I mean, the whole dynamic can flip once you get a judgment in hand. And then the last thing I'll say about contracts is arbitration clause. By and large, and you're going to hear different opinions on this, but in my experience, by and large, arbitration is far quicker and far less expensive than litigation. You're going to hear other opinions on that, but I think that's true by and large. Now, let me just take a moment to discuss what you do if you don't have a contract and you have been screwed, which inevitably you certainly will be. You're not completely without recourse. You can bring an action in court, and it's going to be tougher. Now you have to come up with the evidence like we discussed. But I do want you to know that the law is broken into basically two halves. On the one hand, you have what we call at law. Bit redundant, I know. But it means that you have a contract or there's a statute. There's something to guide the judge. And the judge doesn't have a great deal of discretion in terms of what's in that contract or what the statute says. That's a safer place to be. You want to be at law whenever possible. On the other hand, there is the equity side of the law. And equity is kind of a free-for-all. It just means, as it sounds, fairness. You just have to show the judge that it's not fair for the other side not to pay you for your services. So you'll have to demonstrate the value. Let's go back to that roofing example. So you now have to demonstrate that a roofing job like that is worth $5,000. How do you do that exactly? Well, I don't know. Maybe you bring in the competition. Maybe you show your history of billing for other jobs of similar size. Maybe you bring in an expert, which is expensive, but you get the idea. There is recourse. You can establish these points with enough sufficiency to convince a judge that it's not fair, that this other person benefited. They do have a brand new roof, right? They saw you doing the work day in and day out. They accepted that benefit. And then you, obviously, as the worker, relied to your detriment upon the understanding. So if you can do those things, those are the basic elements of what's called quantum meruit. You can also think of it in terms of unjust enrichment. Those are the basic elements that you have to prove, and I did want you to know that that's available to you if it's too late. If you don't have a contract in place and you are being screwed currently. Part 3, let's get to the main topic here today, the liens that I promised you I'd be talking about. All right, so first of all, you got to be eligible. I covered a good many of the types of workers that are eligible to file a lien. Essentially, it's contractors and subcontractors and subcontractors, laborers, architects, engineers, interior designers. So it's really those who, don't let me forget, material suppliers. Used to be called material men. Apologies again, ladies. So those parties can definitely file liens. I mean, you got to do everything correctly, but you're eligible to file a lien. Who is ineligible? Well, the suppliers of the suppliers cannot impose a lien on a particular property or project. So the Chinese manufacturers are out of luck. And also unlicensed contractors. So if you're doing a job that requires a license that you don't have, that's going to be trickier. Now, put a bookmark on that, because we are going to talk a little bit about filing liens, whether or not you are technically entitled to do so. Okay, there is a notice requirement. You do have to send notice to the owner. Don't forget to do that. I'm not going to get into the details of what that notice looks like or when it has to be served, because it does depend on a few different things. There's the claim of lien itself. That's a document that has to be completed completely and accurately and then recorded at the county courthouse. And that lien has to be filed within certain parameters, which again, I'm not going to get into details. Generally speaking, I'll give you this much. 90 days is kind of the magic number. So within 90 days of having furnished, done the work or furnished the materials, that's pretty much by and large the deadline that you have to hit. So do keep that in mind. You've also got to serve the lien in a timely fashion, which is again that 90-day deadline that we talked about. And then finally, you have a certain amount of time to enforce your lien, which is 1 year. So be aware, it doesn't just stay there forever. Now, it's true that during the period of time that the lien is in place, the owner can't sell the property. And that's generally what gets your phone ringing, right? That's the pressure that we're trying to create, so they have to come talk to you. But just bear in mind that there is a 1-year expiration date. And also there's a way for the project owner, the owner of the property, to speed up that time frame. And that's by filing what's called a notice of contest of lien. I don't think that's a bad thing, but here's what happens. If they file that notice of contest, then now the onus is on you to actually initiate a foreclosure action within a very short amount of time, or else the lien will be dissolved. But I say that I don't know that that's the worst thing in the world, that they file this notice of contest of lien. Of course, you're going to feel the pressure of having to now go out and find a lawyer and file a lawsuit, but at least you have their attention, right? Part 4. Okay, I promised you a superficial treatment, and that was indeed superficial. But there's a reason why I don't want to get into too many details. The first reason is this. It depends, right? It depends upon certain things. So it might depend, for example, upon whether or not you were hired by the owner of the property or project, or whether you were hired by a general contractor. There's actually 2 different statutes, and some of the conditions change depending upon what the circumstances are. So that's one example. Here's another example. If the job was worth $2,500 or less, then your project or your work is exempt of some of the other requirements. So that's the point I'm trying to make, is that I want to try and cover all the possible scenarios and have you taking notes, because you're bound to make a mistake. So it's better that I just do it superficially, because after all, if you just hire my firm, it's not expensive. And it's that's not the only reason I want you to I don't want to go into details here, but after all, if you hire my firm, it's not expensive for us to file the claim of lien on your behalf. We're all set up to do that, and we won't make the mistakes. We'll make sure that you hit all the deadlines, etc., and you can focus on your work. And there's one other main reason why you want to come to us rather than do it on your own, and that is the psychological effect. After all, this is one of the main things we're talking about here. You're in a snake pit, you're in a shark tank, and the psychological effect of a notice coming from a law firm on letterhead goes a lot farther than you just shaking your fist and saying, if you don't pay me by Friday, I'll come back and shake my fist some more, right? They know you're not going to do anything. But if they get my letter on my letterhead, and they will try the same thing. I'm not even going to play with you. They will try the same thing with me, to say, hey, my grandmother, my bank, this circumstance, that circumstance, my heart. Yeah, of course. We're going to hear all that. Just with the same excuses you get, we also get them. But if my letter says that by such and such a date, you haven't resolved this situation to our satisfaction, there will be legal action. When it's on my letterhead, they're going to believe that. And in fact, this is what we do. So if that date comes and goes, I will initiate legal action. While we're on the topic of psychology, this brings me back to what we touched on earlier. Okay, there are certain requirements for filing a valid lien. Okay, now there's a little gray area here. I'm going to go get lawyerly on you, because the gray area, that's where we live. Let's say that even if maybe you haven't done everything technically correct to file a lien, and that those who know better might be able to defeat your lien, in a lawsuit, or just to have the lien dissolved. Nonetheless, it may in some cases make sense to just go ahead and file the lien anyway. And I'm mainly talking about the circumstance where you just can't get any attention. You're getting the runaround so hard that it makes sense for you to just go ahead and file the lien, because if nothing else, your phone is going to ring, and you're going to have their attention. You're going to have an opportunity to potentially discuss some resolution. If they have a savvy attorney on the other side, he may say, dissolve that lien voluntarily, or you're going to end up paying my fees to dissolve it for you. But even then, at least you've gotten their attention. So that's what I have for you guys today on the topic of construction liens and things that are in and around the topic of construction liens. Recuerda que hablamos español, por supuesto. I'm going to take just 1 second to say something, which you have to admit that this is my 19th episode, and I have never said this. You know how podcasters are always begging for likes and subscribes and comments and things like that? I've never asked you for that. I find it, I understand it, of course. We want to get some traction, right? The algorithm. I'm not going to ask you for you to do that, because I assume if you're enjoying the content, you will do all those things. Let's just have an unspoken rule between us. I'll just say, I know you'll do the honorable thing. Talk to you soon. Place. Today's topic is liens, construction and mechanics liens. Now, if you are a general contractor, a contractor,